Swayam Prabha. Digital India. Educated India.
Hello friends, now I have come with the topic protection of children from sexual offences in India. In the 9th session to the course Law relating to women and children. In earlier session, we have discussed the juvenile justice system, the care, protection and the development, the social integration of the children who are in conflict of law or who are in need of care and protection. And before that, we have also discussed the issue of or the subject of the early childhood care, protection and education. In all the topics, in all the discussion which we made on the children, the care, protection and development of the children is the central theme, because the children are not independent, they are not sufficiently mature, they are not like adults, they cannot take the decision what to do and what not in a given circumstance. They are very emotional, they are very sensitive also, and these weaknesses of children make them vulnerable group, and therefore the special care, the special protection, the special treatment is always required for the children. Though in each jurisdiction the criminal law is there to treat the offenders or to treat the offences which are made generally against the human being, but it is also the true fact that the children, they are certainly distinctive in all the aspects, and therefore the offences being done against the children, these are also distinctive, and therefore these should be treated with the distinctive law, with the distinctive approach, with the distinctive procedures, with the distinctive system of law. And therefore, in the recent amendment in the criminal law by Indian legislature, by Indian Parliament, wherein now the IPC, the Indian Penal Code, has been renamed as, the new law has been enacted in place of IPC in the name of Bharatiya Nyaya Sanhita 2023. And it is very good initiative on the part of Parliament that in Bharatiya Nyaya Sanhita a separate chapter, that is chapter 5, is devoted to the offences against the women and against the children, because women and children both are the vulnerable or distinctive groups, and therefore the offences against these two vulnerable groups should be treated distinctively, and it has been done by the Indian Parliament by including one separate chapter on the offences against women and the children. We will talk about those provisions which are included in the chapter 5 relating to the offences against the children. But at the outset of our discussion, we are to know first thing that the child sexual abuse is widely prevalent yet hardly reported. The sexual violence takes place in all settings, at home, at school, at child care institutions, at places of work and in the community. So, no place seems to be absolutely safe for the children, because at all the places the offences are being made, the criminal acts are being done, or sexual acts are being done against the children. And these sexual offences against the children are very prevalent in the society, but these are hardly reported because of some reasons, because of the emotional sensitive status of the children, because of the apprehensions or the fears in the minds of children, that if they will report or they report the incidents of offence, then with what approach or with what attitude their parents, the society, their teachers, etc. will see that incidents, and what would be the effect on those who will hear about the offences, or to whom the child will report about the child himself, whether those persons will not see that child himself or herself guilty of that offence. These are the various apprehensions in the minds of children, and therefore the sexual abuses which are very prevalent in the society and which are being done at all places, even within the homes by the close relatives of the children, these offences, sexual offences against the children are being done, but these are hardly reported. These sexual abuses against the children, these includes all types of sexual victimization of children, like penetrative or non-penetrative sexual intercourses, pornography, sexual harassment, commercial sexual exploitation, sex tourism, and online exploitation. The criminal justice system and the public have always ignored child sexual abuse as a hidden issue in India. Child sexual abuse was not regarded as a crime until recently. In India, the only recognized specific sexual offence against children was rape. Lack of explicit legislation made with regard to it, the variety of objectionable behaviors, including harassment, child sexual assault that did not amount to rape, and exploitation for pornography, were never punished by the law. Sexual violence takes places at all the places. As I told you, in recent years, this stillness or this silence has been broken by the initiatives of some activist non-governmental organizations and the Union Ministry of Women and Child. On the initiatives of the NGOs, on the initiatives of social activists, and on the initiatives of the Union Ministry of Women and Child Development, this silence could be broken. Now we see that such incidences are being reported which were hidden before, and it is very good step towards curbing the sexual offences against the children. If these are reported, then certainly these will be treated accordingly by the law enforcing agencies. And these initiatives of the NGOs, social activists, and the Union Ministry of Women and Child Development, it certainly augmented and amplified the social and political force and the drive to address the issue of sexual offences against the children. Only these initiatives could amplify or could augment the social force, the political force, the drive towards dealing with the offences or sexual offences particularly against the children. The Union Ministry of Women and Children Development steered the initiative, and all these initiatives resulted into the enactment of Protection of Children from Sexual Offences Act 2012 by Indian Parliament. It is also the fact that India has 1/5 child population of the world, and the Indian government estimates that 40% of India's children are vulnerable to threats such as trafficking, homelessness, forced labor, drug abuse and crime, and are in need of protection. The United Nations has defined the child sexual abuse as contacts or interactions between child and an older or more knowledgeable child or adult. He may be the stranger, he may be the sibling, he may be a person in position of authority, he may be a parent, or he may be the caretaker of that child. When the child is being used as an object of gratification for the older child's or adult's sexual needs, these contacts or interactions are carried out against the child using the force, trickery, bribes, threats or the pressures. The Universal Declaration of Human Rights 1948, it is seen to be a basis for all international legal standards for children's rights today. There were several conventions and laws that addresses the children's rights around the world, including historical document which was enacted in 1923 in the name of 1923 Declaration of Rights of Child, and it endorsed by the League of Nations and adopted by the United Nations in 1946. It later served as the basis for the Convention on the Rights of Child, that is the CRC. In 1989, the CRC was agreed to, and CRC is the first legally binding international instrument to incorporate the full range of human rights, civil, cultural, economic, political and social rights of children exclusively. The CRC is based on 4 core principles: the principle of non-discrimination, the best interest, the principle of best interest of the child, the right to life and survival, development, and considering the views of the child in decisions which affect them. So, these are the 4 principles on which the CRC was based. Section 2nd, para 47, the Vienna Declaration and Programme of Action 1993 urges that all nations are to undertake measures to the maximum extent of their available resources with the support of international cooperation to achieve the goals in the World Summit Plan of Action. It calls on states to integrate the Convention on the Rights of the Child into their national action plans. This also requires the member states to introduce effective measures and to take operative initiatives against female infanticide, harmful child labor, sale of children and organs, child prostitution, child pornography, as well as other forms of sexual abuse against the children. And this gave an encouragement and inspiration for the adoption of the optional protocol on the involvement of children in armed conflict and the optional protocol on the sale of children, child prostitution and child pornography. Now, after going through the international initiatives with respect to the rights of children, with respect to the entitlement of the children to be protected, to be cared of against any kind of abuses, including the sexual abuses, it is also necessary for us, when we are talking about the protection of children from sexual abuses in or sexual offences in India, that what is the constitutional mandate or what is the protection given to the children in the supreme law of the land, that is our constitution, with regard to their protection and their care against the sexual offences. See that the Constitution of India recognizes the vulnerable position of children and their rights. Therefore, the Constitution of India contains provisions for survival, development and protection of children. These provisions for the survival of the children, for the development of the children and for the protection of the children are found in Part 3 and Part 4 of our Constitution. Part 4 refers to fundamental rights, directive principles of state policy are found in Part 4. Part 3 refers to fundamental rights. And these important provisions are, again and again I am referring these provisions, and we can understand the importance or the significance of these provisions with regard to the rights of children, with regard to the protection of children, with regard to the care of children, with regard to the education of children, with regard to the development of children, with regard to any entitlement of the children, which entitlement has been recognized by the CRC and other international instruments. And therefore, these provisions of our Constitution are very relevant provisions for developing any law, as we know that if any law is made by any country, and this also applies to India, if any law is made, that law, it comes from, it manifests from the supreme law of the land. There are two aspects. First, that law always manifests from, that law always emanates from, that law always comes from the supreme law of the land, and number two, that each and every law made by the country should be in accordance with the mandate, should be in accordance with the principles, should be in accordance with the provisions of the Constitution, and it is to get its validity, it is to receive its recognition within the Constitution itself, and therefore, the constitutional provisions regarding to the validity of any law made by the legislature in the country are very relevant, and these are the ground or these are the basis on which the validity of any law made by any legislature is examined or is checked. These provisions in the Constitution are Article 15 clause 3, Article 24, this is more important with regard to the protection of children against sexual abuse. In Article 24, it is provided that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Then the directive principles of state policy, particularly Article 39F and Article 45. The state shall endeavour, according to Article 39(5), it is the duty of state that the state shall endeavour that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. See the mandate given in Article 39F, that the state shall endeavour that children are given opportunities and facilities to develop in healthy manner. This is the first direction to the state, that the state is to make such policies whereby the children are given opportunities and facilities to develop in a healthy manner, and then in conditions of freedom and dignity. So, the state should make the policies in which the children can develop in healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. This is very important provision with regard to the protection of children from the sexual abuses or sexual offences. When it is the duty of the state to make such policies which ensures that the children are developed or the children can develop in healthy manner and in the conditions where they are free and they live their life with the dignity. Fair conditions, dignified conditions, and freely they can develop in fair conditions. Any sexual abuse which is committed against any child, certainly it is the hindrance or it is the hurdle in the path of the development of that child. That sexual abuse or sexual offence being committed against the child certainly lowers down the dignity of that child. It imposes a social stigma. It disturbs the mental capacity, the mental state of the child, and in such a situation the child cannot lead a dignified life. Child feels victimized. Child himself understand himself as guilty, and with this element of victimization and guilty, nobody can develop in healthy manner. And therefore, for ensuring that the child or the children they are developed in healthy manner, in fair conditions, with free and dignified life, it is essential for the state to protect the children from any possibility of, from any act of sexual abuses or sexual offences. Then Article 45, we have also referred many times this Article 45. Article 45 gives the responsibility to the state, care, protection and education of the children. Now under the age of 6 years, before 86th amendment that was 6 to 14 years. So the state is again mobilized to make the policies, to make the laws for caring, for giving the proper care, for giving the proper protection, and for making the arrangement or for ensuring the educational development of the child, of the children. So when the state is obliged or duty bound under the constitution via Article 45 that the state is to take the measures or the initiatives for the proper care and protection of children below the 6 years, then this responsibility goes to the state itself, that the proper policies and proper laws should be developed, proper procedures, proper mechanisms should be, proper tools should be developed by the state to protect the children from any possibility of, from any kind of sexual abuses. Further, the children have the right to equality of opportunity under Article 14 and right to dignity and care under Article 21, right to protection and rehabilitation under Article 21 again, by the society with both hands open to bring them into the mainstream of the social life without pre-stigma affixed on them for their no fault. In all these sexual offences which are being committed against the child, they do not have their fault, but without any fault of the children or without any fault of the concerned child, he is always under the burden of pre-stigma or the stigma in his mind, and therefore it violates the right of that child under Article 21. This again gives the mandate to the state to develop proper mechanism, to develop proper procedures, to develop proper legal system to protect the children from sexual abuses or from sexual offences. Then what has been the criminal law before the enactment of POCSO Act or Protection of Children from Sexual Offences Act 2012. Before this enactment, the IPC or Indian Penal Code was the substantive criminal law in India, substantiated or supplemented by the CRPC as the Criminal Procedure Code. Both have been now amended and new enactments have been made. IPC was the criminal law. Now this IPC is substituted by the Bharatiya Nyaya Sanhita 2023. There were certain provisions in IPC, as I have already told you, that only the provision of rape was there which could be invoked for any kind of sexual offence against the children. And if you see the definition or the meaning of rape under section 375 earlier in IPC, then it is very difficult to prove the rape. That was the only provision, and therefore there were the problems to tackle the offences against the children, which were very hardly reported and which may not amount to be the rape. Then some other provisions were included later on. Now, under the Bharatiya Nyaya Sanhita, I have already told you that a separate chapter has been included for the offences against the women and children. So, we will see that what are these provisions in IPC and now what are the provisions in Bharatiya Nyaya Sanhita to deal with the offences against the children. In Bharatiya Nyaya Sanhita, one chapter, that is chapter 5, has been devoted to the offences against the women and children, and in this chapter the following provisions are related to the offences against children. That is section 93. Before Bharatiya Nyaya Sanhita, in IPC there was no separate chapter, there were no separate provisions for dealing with the offences against children, and therefore I am saying that this is very effective initiative, very good initiative with regard to the protection of children from sexual offences, that the Indian Parliament included certain provisions in Bharatiya Nyaya Sanhita 2023 which deal exclusively with the offences against the children, and these starts with section 93 of Bharatiya Nyaya Sanhita. See section 93 of Bharatiya Nyaya Sanhita. Section 93 of Bharatiya Nyaya Sanhita makes exposure and abandonment of child under 12 years of age by parent or person having care of it an offence. So, if any person, any parent or any person exposes or abandons a child under the age of 12 years, it is now offence under section 93. It shall be punished with imprisonment of either description for a term which may extend to 7 years, or with fine, or with both. And for the exposure and the abandonment of a child under the age of 12 years by the parent or any person, now it is offence and it is punished by a term which may extend to 7 years imprisonment and with fine. So, 7 years maximum imprisonment of 7 years and fine, this is the offence. Then section 94, concealment of birth by secret disposal of dead body. We sometimes see the incidences where the children are disposed, the dead bodies of children are disposed and nobody take care of such incidences. Female foeticide, then after the disposal of the early female children, that is made in this way. So, if there is the concealment of the birth of a child, or the secret disposal of dead body of a child is made, it is punishable under section 94 with imprisonment for a term which may extend to 2 years or with fine or with both. So, 2 years imprisonment plus fine is the punishment for the concealment of the birth of any child if the parents conceal the birth of any child or the dead body of any child is disposed of secretly. Section 95 refers to the hiring, employing or engaging a child to commit an offence. Hiring any child, employing any child or engaging any child for committing an offence is now punishable under section 95, and it shall be punished with the imprisonment of not less than 3 years and which may extend to 10 years. So, minimum punishment has been prescribed as 3 years and the maximum punishment are the 10 years and the fine. And if the offence be committed, shall also be punished with the punishment provided for that offence, that as if the offence has been committed by such person himself. The hiring, employing, engaging or using a child for sexual exploitation or pornography is covered within the meaning of this section. So, this is very important provision which deals with the protection of children from sexual offences when the hiring of a child, the employing of a child, engagement of a child, use of a child for sexual exploitation, for pornography is covered within the meaning of this section. Then section 96, procuration of child. If any child is procured by a person, it is now an offence under 96 and it shall be punishable, or for that offence the person shall be punished for the imprisonment of 10 years and the fine. Section 97, kidnapping or abducting child under 10 years of age with intent to steal from its person. Now, see, the procuration of child under 96 has been made punishable with the imprisonment of maximum 10 years and with fine. The procuration of children, only the procuration, then the question may arise in your minds that only the procuration of a child or procuration of children, how it may relate to the sexual offences against the child or children. So, when the procuration, because we see that the procuration is always made either for the purpose of sexual exploitation or for the purpose of exploitation by way of the child labour. These may be two important aspects for which any child or the children are procured by anybody. So, if the procuration is made punishable, that means because it is very difficult to prove that the sexual abuse has been done or the sexual abuses are being done against the child which is procured by a person, as I have already told you that the sexual offences against the children are prevalent, but they are hardly reported. So, the child may not, by under pressure or due to the fear or due to any pressure, the child may not report the incidence of sexual offence, and therefore, it would be very difficult to prove that the procured child is also subjected to the sexual exploitation. And if only the procuration is punished or is made punishable, it means that the procured child cannot be, when the procuration itself is the offence, then the further sexual exploitation or sexual abuse may not be possible if we protect the child against even the procuration, and therefore, this offence is also very, this section or this provision 96 or this offence of procuration of a child is also very relevant provision for the protection of children from sexual abuses or sexual offences. Then kidnapping or abducting child under 10 years of age with an intent to steal from its person. Again, with the same logic, with the same reason, we can understand that how this section 97 is relevant to protect the children from sexual offences, and this kidnapping, abduction of a child under the 10 years of age is also made punishable with the imprisonment for a term of maximum 7 years and fine. Now, see section 98, selling child for the purpose of prostitution, which directly relates to the sexual abuses or sexual offences against the children. This selling of child for the purposes of prostitution is now punishable with the imprisonment of either description for a term which may extend to 10 years and shall also be liable for fine. Section 99, buying child for purposes of prostitution. So, the selling of child has been made punishable under section 98, and buying of child for the purpose of prostitution has been made punishable under section 99. This buying of child for the purpose of prostitution has been made punishable with the punishment for a term minimum 7 years and maximum 14 years, and also the fine. Then after the provisions of Bharatiya Nyaya Sanhita, which deal with the protection of children from sexual offences or the protection of children against the offences or any crimes. Now, we see the provisions of the Protection of Children from Sexual Offences Act 2012. To deal with the sexual abuse cases, the Indian Parliament or the Government of India, by way of legislative competence, legislative authority of Indian Parliament, brought in a special law, namely the Protection of Children from Sexual Offences Act 2012, and this act, this law, protect the certain rights of children. What are these rights? Just see. The rights which have been protected by the Protection of Children from Sexual Offences Act 2012, these rights are right to life and survival, the right to best interest of a child, the right to be treated with dignity and compassion, right to be protected from discrimination, right to special preventive measures, right to be informed, right to be heard and express views and concerns, right to effective assistance, the right to privacy, the right to be protected from hardship during the justice process, the right to safety, the right to compensation. These rights have been defined, these rights have been guaranteed by this act, and the child is defined in the act as any person below the age of 18 years. Any person below the age of 18 years would be considered as a child for the purpose of POCSO. The POCSO Act is gender neutral act, it is applicable to both the boys and girls. The definition of sexual offences is very broad and not restricted only to rape or the related crimes. It covers many kind of sexual offences. For example, section 3 talks about the penetrative sexual assault, section 5 relates to aggravated penetrative sexual assault, section 7 sexual assault, section 9 aggravated sexual assault, section 11 sexual harassment of the child, use of the child for pornography purposes is dealt with by section 13. Offence is aggravated in first two, in section 5 and in section 9C in section 3 penetrative sexual assault, then in section 5 aggravated penetrative sexual assault, in section 7 sexual assault, then in section 9 aggravated sexual assault. When any assault or when any offence becomes aggravated, it has also been clarified by the Act. According to the provisions of the Act, any offence becomes aggravated offence when it is committed by a person in position of trust or authority, such as police, army, security personnel, public servants or family members. Then this offence becomes the aggravated offence. When it is committed by persons in management or staff of educational, medical or religious institutions, when the offence is committed by persons in management or staff of jail, remand home, protection home, observation home or any other place of custody or care and protection. Any offence becomes the aggravated offence when it amounts to gang assault, when it causes the grievous hurt, when the offence causes physical or mental disability. The offence becomes the aggravated offence when it is committed taking advantage of child's mental or physical disability. Any offence becomes aggravated offence when it is committed more than once. Any offence becomes aggravated offence when it is committed against the child below the 12 years. Any offence is aggravated offence when offender is relative of the child. The offence becomes the aggravated offence when the attempt is also made to murder of the child. Offence becomes aggravated offence when it is committed and child is made to strip and or paired naked in public. The offence is the aggravated offence when it is committed by a person who has been previously convicted of having committed such an offence either under this law or any other law. The offence becomes the aggravated offence when offence is committed in course of communal or sectarian violence. Then what is the punishment for the offences being committed under the Act? In section 3, the penetrative sexual assault is defined, that what is the penetrative sexual assault. In section 4.1, for that penetrative sexual assault, the punishment has been prescribed, which is 10 years, minimum 10 years and maximum life imprisonment plus fine. And when the penetrative sexual assault on a child below 16 years of age is made, then imprisonment of 20 years and it may extend to imprisonment for life. So, minimum 20 years. When the penetrative sexual assault was made, it was minimum 10 years and maximum life imprisonment. When the penetrative sexual assault is made on a child below the age of 16 years, then the minimum punishment is 20 years imprisonment and the maximum the life imprisonment, and the life imprisonment would be treated distinctively in this manner to make the punishment more stringent, that till the end of the natural life of that person, that punishment or imprisonment shall continue. Aggravated sexual assault. The imprisonment is prescribed by section 6 subsection 1, minimum 20 years and maximum life punishment. Fine is included in all the sections. Then sexual assault with sexual intent touching the private parts of the child. If any sexual assault is made with the intention to touch the private parts of the child, then the punishment is prescribed in section 10. This action is made an offence under section 7 and punishment is prescribed under section 10, which is minimum 5 years imprisonment and maximum 7 years imprisonment plus fine. Aggravated sexual assault. When the sexual assault by a police officer, member of a armed force, public servant, staff or remand home, jail, hospital, school, etc. in section 9, this is the aggravated sexual assault. 7 years minimum punishment is given and maximum life imprisonment. Sexual harassment with sexual intent, section 11, 3 years imprisonment, 3 years imprisonment and the fine. Use of child for pornographic purposes, section 13, this is the offence. On the first conviction, imprisonment is maximum of 5 years plus fine, and for second or subsequent conviction, punishment up to 7 years imprisonment plus fine according to section 14 subsection 1. Whoever using a child or children for pornographic purposes under subsection 1 commits an offence referred to in section 3 or section 5 or section 7 or section 9 by directly participating in such pornographic acts shall be punished for the said offence also under section 4. Yani the use of a child for pornographic purposes would be punishable under the above mentioned actions, and the punishment would also be given retrospectively in addition to the punishment provided in subsection 1, that is section 14 subsection 2. Section 14 subsection 2 provides for the punishment. It makes the act of using child for pornographic purposes as punishable, and punishment is provided in addition to this punishment under section 14 subsection 2. The earlier punishment which was there in earlier sections, that would also be inflicted. Then if anyone stores the pornographic material by directly involving the child for commercial purposes, then section 15 prescribes the punishment for as the imprisonment or fine or both. It is minimum for 3 years and maximum for 5 years. Reporting the incident, what is the procedure? Procedure is that the report shall be made to the local police station under section 19. Recording of a statement by the authority within 24 hours is required. Then section 19 subsection 5 gives the responsibility to the authorities to take the child to the center home or the hospital, take the child for medical examination by female doctor under section 27 subsection 2 and rule 5 made under the act. Recording of the statement by the magistrate is provided under section 25. CWC to determine child's stay within 3 days, Child Welfare Committee, which is created under the Juvenile Justice Act at each district or district level. If the police report indicates that a child is in need of care and protection, then the rule 4 provides that CWC is required to determine the stay of the child within 3 days. A special court shall complete trial within 1 year of cognizance. From the date of cognizance, that the case should be determined within 1 year. The court shall complete to make the procedure of such offences or such cases more expeditious. This rule, it is provided in the act that the special court shall be created, established, and those courts shall complete the trial within 1 year of the cognizance. Rule 4 provides the restoration to family or guardian or person. Restoration after all these formalities. The restoration of a child to the family or guardian. Rule 4 sub rule 4 talks about the children home, shelter homes, rule under section 19 subsection 5 and rule 4.4. Counseling of the concerned child is provided under section 40. Support person, rule 4 sub rule 4. Then the child to be provided help of interpreter, translator, special educator. It is provided under section 19 subsection 4 and rule 3 sub rule 67. It is also important or it is also necessary to take measures to prevent victim coming face to face with the accused under section 33 subsection 7 and under section 36. This care or the caution has been taken by the act that the victim should not come face to face with the accused. Then rule 7 provides for the victim compensation and section 32 talks about the prosecution by the special public prosecutor of such offences. Section 21 subsection 1 of the POCSO Act requires mandatory reporting of the cases of child sexual abuse to the law enforcement authorities and applies to everyone including parents, doctors and school personnel. So, nobody is relaxed or exempted from this responsibility. Mandatory reporting of the cases of child sexual abuse shall mandatorily be reported to the concerned authorities. Failure to report a suspicion of child abuse is an offence under the Act, punishable with the imprisonment of either description which may extend to 6 months or with fine or with both. The nature of sexual abuse, the shame that the child victim feels and the possible involvement of the parent, family, friend or other close persons makes it extremely difficult for the children to come forward to report sexual abuses. This is why the law provides for mandatory reporting, placing the responsibility to report not on the child but on a surrounding adult who may be in a better position to help. The child may hesitate to report the incident and therefore, the responsibility of mandatory reporting is cast on the surrounding adults. It is also the good initiative on the part of the legislation that the Act does not lay down that a mandatory reporter has the obligation to inform the child or her parents or guardian about her duty to report. Any person who makes false complaint or provides false information against any person in respect of an offence committed under these sections with the intention to humiliate, exhort or threaten or defame him shall also be punished, because that trick may be used to defame the child or to make him victim of such offence, then it is also punishable, imprisonment for a term which may extend to 6 months and with fine. These are the reasons which we have already discussed, that why the incidences of sexual offences against the children are not reported. Role of special courts is provided under section 28 and section 29. The onus lies on the accused to prove innocence under section 29. This is also the unique feature of the Act. Otherwise, in criminal law, we see the presumption of innocence, but section 29 places the onus of proof on the accused, and the child protection mechanism, it is a need. Stopping child sexual abuse is essential. The Indian community should make concerted effort to stop child sexual abuse in the country. It is not only the responsibility of the government to keep children safe and secure, but it is also the responsibility of all of us to ensure a safe and protected environment for our children, to enable them to live with dignity and free from any form of violence. And therefore, we all are responsible to take care of such incidences which are committed against the children, and the obligations which have been imposed over the surrounding adults under the act should be very happily accepted by all, so that we can protect our children from any possibility of sexual offences against them. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said, but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered. And indeed, the very charm of this particular story that I'm going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia, which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.